Get ready for a legal travesty so grotesque it'll sear itself into your soul. It's March 6, 1857, and a hush falls over a packed Supreme Court chamber in Washington, D.C. The air is heavy with cigar smoke and anticipation. The bench is crammed with lawmakers, reporters, and onlookers from every corner of a fractured nation. At the center of it all stands Dred Scott, a man born into slavery, a husband, a father, who dared to dream of freedom and drag his case to the highest court in the land. He wasn't asking for much, just a recognition that living on free soil might unshackle him and his family from bondage. But this wasn't a fair fight. The courtroom bristled with power. White men in black robes, their pens poised to rewrite history. The stakes? Nothing less than the soul of America, a nation already splitting at the seams over slavery. What Scott got wasn't justice. It was a sledgehammer to human dignity, a ruling so vile it branded the Supreme Court as a puppet of oppression. This wasn't just a decision. It was a declaration of war on hope, a betrayal so deep it still scars us today. How did a single man's plea for liberty ignite such a firestorm? Step into that courtroom with me, and let's unravel the moment when America's promise of freedom turned to ash for millions. Picture Dred Scott, born around 1799 in Southampton County, Virginia, a land soaked in the blood of enslaved labor and the echoes of Nat Turner's rebellion. His early years are shrouded in shadow. His birth name possibly sang before he took the name Dred, owned by the Blow family. He toiled in field and households, his body bent under the lash, his mind sharp despite laws forbidding slaves to read or write. Scott defied those odds. He learned letters, maybe from a sympathetic soul or stolen moments with a discarded Bible. By 1830, he'd moved to St. Louis, Missouri, a bustling river town where the Mississippi carried whispers of freedom and chains. There, he met Harriet Robinson, a young enslaved woman owned by a different master. Their love was an act of quiet courage, a bond forged in defiance of a system that saw them as less than human. They married in 1836, a union blessed in a free territory, and soon welcomed two daughters, Eliza and Lizzie, girls born into slavery but cradled by parents who dreamed of more. That dream took root when their enslaver, Dr. John Emerson, a restless army surgeon, uprooted the family. In 1834, Emerson hauled them to Fort Armstrong in Illinois, a free state under the Northwest Ordinance of 1787, which banned slavery north of the Ohio River. For 2 years, they breathed free air, Scott laboring as a handyman while Harriet cooked and cleaned. Then, in 1836, Emerson dragged them further north to Fort Snelling in the Wisconsin Territory, land explicitly shielded from slavery by the Missouri Compromise of 1820. Amid the pine forests and frigid winters, the Scotts built a fragile life, their daughters toddling on soil where bondage was forbidden. Scott worked odd jobs, squirreling away pennies, daring to imagine a future unchained. But freedom was a mirage. When Emerson died in 1843, his widow, Irene Sanford Emerson, inherited the Scotts, cold and calculating. She refused to free them, instead hiring them out for profit, a legal limbo that mocked their years on free soil. That's when Dred and Harriet made their move. In 1846, bolstered by abolitionist allies like the Blow sons, now grown and repentant of their family's past, they filed suit in St. Louis, arguing that their residency in free territories made them free. It was a desperate, audacious gamble, a spark of hope in a nation sliding toward chaos. The case ignited like a slow fuse in a powder keg. Scott's first suit hit the St. Louis Circuit Court in 1846, a gritty brick building where justice was often a luxury for white men only. Missouri was a slave state, its laws a tangled web designed to keep black people in chains. Yet Scott had precedent. Slaves had won freedom in similar cases, citing residency on free soil. His initial filing stumbled on a technicality, proving Irene owned him. But in 1847, he refiled with Harriet as co-plaintiff, their daughter's futures hanging in the balance. After years of delays, the trial finally came in 1850. The courtroom buzzed as a jury of 12 white men heard testimony. Neighbors who'd seen Scott in Illinois, old soldiers from Fort Snelling. Against all odds, they ruled for Scott, declaring him free. For a fleeting moment, He walked St. Louis a free man, his family at his side. But Irene wouldn't relent. She appealed to Missouri Supreme Court, where pro-slavery judges bristled at the verdict. In 1852, they overturned it, ruling that Scott's time on free soil didn't matter. Missouri law trumped all else. Times now are not as they once were. Justice William Scott sneered, slamming the door on decades of precedent. Undeterred, Scott's legal team, now funded by abolitionists like Charles Drake, pushed the case federal. By 1854, it landed in the U.S. District Court, pitting Scott against Irene's brother, John Sanford, misspelled Sanford Records, who'd taken control of her estate. The federal judge upheld Missouri's ruling, but Scott's lawyers saw one last shot: the U.S. Supreme Court. In 1856, the case docketed as Dred Scott versus Sanford grabbed national headlines. America was unraveling. Bleeding Kansas pitted pro-slavery raiders against abolitionist settlers. The Whig Party was crumbling, and the new Republican Party rallied against slavery's spread. Two questions loomed. Could living on free soil free a slave? Could a black man even sue in federal court? The answers would either douse the flames or blow the nation apart. And the court, led by Chief Justice Roger B. Taney, a gaunt, 80-year-old Marylander who'd once owned slaves himself, was about to decide. On March 6, 1857, after a year of deliberation, the Supreme Court delivered its verdict, 7-2 against Scott. The chamber was stifling, Taney's voice a raspy growl as he read the majority opinion, a document so sweeping it rewrote the Constitution itself. This wasn't just a loss, it was annihilation. Taney didn't merely deny Scott's claim. He gutted the very idea of black humanity. Negroes, he declared, whether free or enslaved, are not and cannot be citizens of the United States. They were, he wrote, beings of an inferior order, with no rights which the white man was bound to respect. Pause there. The highest court in the land didn't just reject Scott's plea. It erased his personhood and that of millions in a single stroke. Taney leaned on a twisted history, claiming the Founding Fathers saw black people as property, not people, despite evidence of free black voters in 1787. It was a lie dressed as law, a justification for inhumanity. But Taney wasn't done. He turned his pen on the Missouri Compromise, the 1820 pact that had kept slavery below the 36-degree 30-foot line. Congress, he ruled, had no authority to ban slavery in the territories. It violated the Fifth Amendment's protection of property, slaves included. The decision tore up decades of compromise, handing slaveholders a blank check to spread their peculiar institution north and west. The courtroom gasped. Justice Benjamin Curtis, one of two dissenters, later resigned in disgust, calling Taney's reasoning a disgrace. The other dissenter, John McLean, warned it would carry us back to a period of civil dissension. They were right, but too late. Taney's ruling wasn't just bad law. It was a judicial Molotov cocktail, lobbed into a nation already ablaze. The fallout was immediate and ferocious. Abolitionists roared in defiance. Frederick Douglass, his voice booming at rallies, branded the decision a judicial incarnation of wolfishness, a hell-black judgment that mocked the Constitution's promise. Northern papers erupted. The triumph of slavery, screamed the New York Tribune, while Bostonians burned Taney in effigy, his straw-stuffed likeness swinging from lampposts amid jeers. In Philadelphia, free black communities mourned, their fragile citizenship snatched away. Meanwhile, Southerners celebrated like it was a second Independence Day. The Richmond Inquirer hailed it as a final settlement, a victory for states' rights over meddling Yankees. President James Buchanan, a spineless Pennsylvanian, grinned in relief, having secretly pressured justices to back the South. He'd hoped it would end the slavery debate. Instead, it lit a fuse. The Republican Party, born just 3 years earlier, found its rallying cry. Abraham Lincoln, a gangly ex-congressman from Illinois, took the stage in Springfield in 1858, his voice sharp with outrage. A house divided against itself cannot stand, he warned, calling Taney's ruling a burlesque upon judicial decisions, a perversion of justice that spat on the Declaration of Independence. The decision didn't unify. It polarized. In the North, it swelled anti-slavery ranks. In the South, it emboldened secessionists. By 1860, Lincoln's election would snap the thread, and the Civil War's first shots at Fort Sumter in 1861 would echo back to that courtroom. Dred Scott didn't just lose a case. He tipped the nation into war. And Dred Scott himself? His story ends in a bittersweet twist. Irene Emerson had remarried a New Englander, Calvin Chaffee, an abolitionist who squirmed at owning slaves. In May 1857, just weeks after the ruling, she sold the Scotts to Taylor Blow, son of their original enslavers, now a repentant foe of bondage. Blow freed them on May 26, 1857, in a quiet St. Louis ceremony. After 11 years of fighting, Scott was free, not by law, but by a fluke of fate. He took a job as a porter, his family renting a modest home near the river. But freedom came too late, worn down by decades of toil and tuberculosis. He died on September 17, 1858, barely 18 months a free man. His grave in St. Louis's Wesleyan Cemetery became a pilgrimage site, a testament to his fight. Harry outlived him, raising Eliza and Lizzie in a freer but still hostile world. She died in 1876, having witnessed the 13th Amendment abolish slavery in 1865 and the 14th Amendment grant citizenship in 1868, both born from the ashes of her husband's defeat. Eliza and Lizzie faded into history, their lives a faint echo of their parents' resilience, but the ruling shadow stretched far beyond them, a wound on the nation's soul that no emancipation could fully heal. The Dred Scott decision was a moral and legal shipwreck. It exposed the Supreme Court as a tool of power, not justice, twisting the Constitution to shield slavery. Taney's activism, ignoring precedent, mangling history, set a precedent for judicial overreach. It fueled secession. By 1861, 11 states broke away, citing Taney's logic as their shield. The Civil War's 620,000 dead, the Emancipation Proclamation, the Reconstruction Amendments, all trace back to that 1857 ruling. The 14th Amendment, ratified in 1868, was a direct slap at Taney, declaring all persons born or naturalized in the United States citizens. Yet the court's credibility lay in tatters, its rulings suspect for decades. Not until Brown versus Board of Education in 1954, striking down school segregation, did begin clawing back legitimacy. Facing Dred Scott's ghost head-on, here's the gut punch. Dred Scott's echoes still haunt us. Today's battles over race, rights, and citizenship, voter suppression laws in Georgia, reparations debates in Congress, Supreme Court rulings on affirmative action or immigration, carry a shadow. Who gets to be American? Who gets justice? The court, now as then, mirrors our deepest flaws. In 2018, when it upheld Trump's travel ban, critics saw Taney's spirit, power trumping principle. In 2023, as it tackled voting rights, the stakes felt eerily familiar. Can the Supreme Court redeem itself? Or is it doomed to repeat 1857 sins? That's the thread we're still pulling. In the next chapter, we'll dive into one of those modern scars, how Dred Scott's legacy bleeds into today, and why this story grips us like a vice. Stay tuned.